Statelessness, law definition and protection. Statelessness represents a profound challenge to the international system of nation-states, affecting an estimated 10 to 12 million people worldwide. Stateless persons, often referred to as legal ghosts, are among the most vulnerable and marginalized groups globally, enduring a precarious existence due to their lack of formal status. Lacking a formal legal identity upon birth, stateless persons are frequently denied access to fundamental human rights, including education, healthcare, legal employment, property ownership, and freedom of movement. The continued existence of large stateless populations poses significant concerns regarding human rights, stability, social cohesion, and security. To address this pervasive issue, the international community has developed a legal framework centered on defining statelessness, preventing its occurrence, and protecting the rights of those who are already stateless. The cornerstone of the international legal approach to statelessness is the definition set out in the 1954 Convention relating to the status of stateless persons. Article 1 of this convention defines a stateless person as a person who is not considered as a national by any state under the operation of its law. This definition establishes the formal, or de jure, concept of statelessness, focusing purely on the absence of a legal bond of nationality. This internationally endorsed definition is recognized by the International Law Commission, ILC, as customary international law. However, the issue is complicated by the existence of de facto stateless persons, a term not defined in any international treaty. De facto stateless persons hold a nationality in law but are unable or unwilling for valid reasons to avail themselves of the protection of that country. UNHCR employs an operational definition where de facto stateless persons are those outside their country of nationality who cannot access diplomatic or consular protection. While the term de facto statelessness lacks formal legal significance under the 1954 Convention, international law, particularly through non-binding recommendations in the final acts of the Statelessness Conventions, has encouraged states to extend benefits to these individuals, often aiming for them to achieve an effective nationality. The international legal framework addressing statelessness is dual-pronged, focusing on prevention and protection, often encapsulated in two primary instruments. The 1961 Convention on the Reduction of Statelessness is specifically designed to prevent new cases from emerging. Statelessness arises from multiple causes, including technical gaps or conflicts between nationality laws, state succession, dissolution of states or transfers of territory, and discriminatory policies based on grounds like gender or ethnicity. The 1961 Convention mandates specific safeguards for states to include in their domestic laws to avoid these outcomes. For example, it prescribes granting nationality to a child born on state territory who would otherwise be stateless. It permits the loss, deprivation, or renunciation of nationality only under strictly delineated circumstances, ensuring that statelessness is generally not the result. The broader human rights framework buttresses these preventative efforts. The right to a nationality is enshrined in Article 15 of the UDHR, and international human rights law sets essential limits on the sovereign discretion of states in determining nationality. Specifically, human rights norms prohibit the arbitrary deprivation of nationality, including denial of citizenship resulting from discriminatory grounds. For those who are already stateless, the 1954 Convention relating to the status of stateless persons aims to provide protection. This instrument grants the status of stateless person and establishes a comprehensive catalog of rights and minimum standards of treatment. The Convention's protection scheme is complex, often linking the enjoyment of rights to the stateless person's level of attachment to the contracting state, such as physical presence, lawful stay, or habitual residence. The required standard of treatment also varies. For rights deemed essential for basic welfare, such as elementary education, rationing, and public relief and assistance, the Convention mandates national treatment, the same treatment as accorded to nationals. For other rights like wage-earning employment, self-employment, and movable property acquisition, states are required to grant treatment not less favorable than that accorded to aliens generally in the same circumstances. Furthermore, the 1954 Convention addresses the special needs arising directly from statelessness. It guarantees free access to courts of law and protection from expulsion, which is permitted only on grounds of national security or public order and only in pursuance of a decision reached with due process of law. The Convention is critical in securing documentation for this population. Contracting states must issue identity papers to any stateless person in their territory who lacks a valid travel document, and must issue travel documents to those lawfully staying. Crucially, the Convention includes provisions promoting the definitive resolution of statelessness, urging states to facilitate the assimilation and naturalization of stateless persons and to expedite proceedings, a key right of solution. Despite this protective framework, significant deficiencies persist, often undermining the practical enjoyment of rights. A major flaw in the 1954 Convention is its failure to grant stateless persons a right to enter or reside in the territory of a contracting state. Since many rights under the Convention are conditioned on achieving a status like lawful presence or lawful stay, the inability to secure lawful residence leaves stateless persons vulnerable to indefinite detention, expulsion, or the ping-pong effect of being forcibly moved between states. Stateless persons must also rely on general human rights law for protection against abuses like human trafficking and arbitrary detention, as the 1954 Convention does not explicitly address freedom from arbitrary detention. Another critical gap is the lack of a universally agreed mechanism for statelessness determination procedures, SDPs. SDPs are essential for states to identify stateless persons, fulfill their obligations under the Convention, and assess the causes and scale of statelessness within their borders. Currently, international actors like UNHCR are engaged in concerted efforts, such as the Global Action Plan to End Statelessness, to encourage states to ratify both the 1954 and 1961 conventions and establish robust determination procedures to resolve existing situations and improve protection. Ultimately, while the law provides foundational definitions and protective principles, the full realization of rights for stateless persons hinges on comprehensive domestic implementation and a renewed commitment from states to honor universal human rights regardless of nationality status.